This is Lysha Holmes, and I'm your host on the Recruiters Recruitment Podcast. And if you've been watching previous seasons, you will know that in season 5, we had the most incredible guest on who I had to invite back. I was implored to do so, not least because she's a brilliant, brilliant presenter and a fountain of knowledge on all things legal, but more importantly, because her actual episode that she shot with us in season 5 on restrictive covenants was one of our most downloaded and one of our most engaged ones, I think, ever. I don't think I've ever had so many messages on LinkedIn from recruiters asking about a link to it and they'd heard all about it. So, when you have someone who's that famous, you have to get them back on again. And she's somebody who I hold very dear, not least because of her incredible role within our community at the Women in Recruitment Leadership as well. So, welcome back to Hannah Morrison, who is Legal Director at Brabners. How are you?
Thank you for the very generous introduction. I'll do my best to live up to the hype,
Wow.
but delighted to be back.
Yeah, it's all true. And it really was, when we did that podcast, I think we recorded it quite a long time ago because I always record in advance, as you know. I didn't expect it to, I mean, I knew it would have an impact because it's a topic that never goes anywhere. As my day job, as a
Mm.
rep to rec, it's probably the most talked about thing apart from what we're going to talk about today. And it was really useful. And I think what's brilliant about it is that unless there's any new legislation coming in, it's pretty evergreen as well. So it's very useful. So if you don't know what I'm talking about, go and have a look. Go and search in your wherever you're listening to this. Put into the archive the restricted covenants with Hannah Morrison and the Recruiters Recruitment Podcast, and I promise you, it's really insightful. But we're not going to talk about that today, are we? We're going to talk about, and you've clicked on this because we said we're talking about it, the Employment Rights Bill, which, if you are in the UK, is a three-letter acronym that has been in our language since October 24th, so literally a year ago. And I'm going to assume the role today, which, much to Hannah's amusement, as the thick person who has no clue what it actually is. And the reason I'm going to take that role is because I think it's important that we start that as a base point of what can we be doing right now as leaders, as business owners, but actually as recruiters to be educating ourselves and to preparing ourselves for whatever is ahead. So, first and foremost, what is it, Hannah?
So the Employment Rights Bill is a piece of draft legislation. That's why it's called a bill and not an act. And when it eventually gets royal assent, which we think is going to be around about sort of September, October 2025, it will become the Employment Rights Act. And it came about out of the Labour Party's manifesto prior to the general election, and what they were calling their plan to make work pay. So naturally, one of the primary concerns of the Labour Party is workers' rights. And they felt that over time, the sort of pendulum had kind of swung too far in favour of the employer, expecting a lot of flexibility from the workforce without necessarily giving them sort of rights and consistency and predictability of working hours and pay and that sort of thing. So Labour produced this plan to make work pay, which set out all of the things that they were proposing to do if they got into power, and they did. And the Employment Rights Bill is effectively them trying to put that into legislation. Now, they committed to doing a lot of things. The Employment Rights Bill has been said to be the biggest sort of shake-up to workers' rights in a generation. I think that's probably fair. I try as a lawyer not to be sensationalist. I don't think that's helpful, but there are a lot of changes coming, and actually changes that are going to affect the recruitment sector in particular. So the Employment Rights Bill really, I think, should be seen more as a framework. It's not hugely detailed. There are lots of sections in it about changes to unfair dismissal rights, paternity leave, guaranteed working hours, all sorts of different things. But actually, when you look at each of those sections, it it generally says something quite high level, like, the government will make changes to the qualifying period to claim unfair dismissal, without necessarily setting out how that's going to actually work in practice. So we've sort of got this framework and this notion that was put out there that there are going to be all of these changes, but actually we don't have all the detail yet, which I think naturally has caused a bit of unrest in the sector and across employers generally, because they know some
Yeah.
something's coming, but they don't know what yet. So um, I think the important thing to say at this point is the Employment Rights Bill is not an act yet. It's still in draft. And even when it gets royal assent, as I say, it lacks the sort of the detail that we need to understand how these things are actually going to work in practice. And the way we're going to get that detail is through sort of secondary legislation regulations, and drafts of those regulations will be released in due course. And the government has also committed to consulting with the public and with businesses on certain key areas. So, for example, day one unfair dismissal rights and the proposed regulation of umbrella companies are two things that the government has committed to consulting on in autumn of this year. So I think we can expect in sort of September, October time to see some consultations released where the government is asking for businesses' views on, how these regulations are going to work, if we foresee any particular difficulties with them. And I guess the point just to make at this stage is obviously we're recording this at the
Yeah.
beginning of
Yeah.
September, but there'll be a bit of a delay until this episode is actually released. So it's possible that some of the things I say now might have developed a little bit by the time this podcast is released, but I'm not expecting they're going to have changed significantly. I think probably the only thing that might happen between now and then is the release of these consultations, which if there is still time at the point that you're listening to this, I really implore you to get involved, because the more voices that kind of respond to these consultations, and if they're making consistent points that look, we don't really see how this proposal is going to work in practice given our knowledge of the recruitment sector, so much the better.
Yeah.
But also, if things have moved along by the time that this podcast is airing, there are links that me or Lysha can provide so that you can find out where things are up to, or if anything significant develops. I always post about it on LinkedIn, so you'll see it that way.
Yeah, no, that was the caveat that will be all over the show notes as well. But we always, everyone, if you're listening to this now, you know that we record a little bit in advance. But I think for this particular episode, it's particularly poignant because things are significantly going to change if those consultations come up between now and the release date, where we don't want this to seem like you're not up to date, because you are up to date with it. But I think what you said there is, my understanding as a recruiter and as an employer. And when you have those sort of, like you say, those big sweeping statements, it can get quite daunting to know what you're doing for the best. And the cascade effect of that can be, unhelpful gossip and also, people pertaining to be experts and, snake oil people who are, trying to sell you the solution to avoid incurring any kind of issues in the future. So you mentioned there around the umbrella companies, because obviously that's a huge part of our industry. So just explain to me where that liability lies with umbrella companies and what the legislation is potentially going to look like.
Yeah, so there's two aspects to this actually. So the first is in relation to tax. So the government perceives that there are umbrella companies out there who are effectively evading tax.
Okay.
And let's be honest, there are some. And I think it's sort of naturally when you think about a labour supply chain, and sometimes you have very, very complex ones with, a managed service provider and then an agency and maybe another agency and then an umbrella. And the further you get down the chain, sometimes the more murky it is, or the less kind of due diligence the parties at the top of the chain are doing. And so, there are some rogue players out there in the umbrella market using sort of tax avoidance schemes like mini umbrella companies, for example. And ultimately, there is a cost to the exchequer because they're not paying the proper tax and national insurance, and also probably not giving the umbrella employees their employment rights, holiday pay, that sort of thing. So one aspect of the proposed changes is in relation to tax, and the proposal is that essentially the agency which is closest to the end client
Yeah.
will be jointly and severally liable with the umbrella company, if there is one in the chain, for that umbrella company's PAYE liability.
Right.
So if that umbrella company does not pay the correct amount of tax and national insurance to HMRC can go after the top agency. So
Right.
if you've got, for example, an MSP in relationship with a client, and then beneath that a whole bunch of agencies, and beneath them one or more umbrella companies, that MSP is the one with the relationship with the end client, and they would be the one that would have this liability. Um, Now, something which I think perhaps the industry wasn't envisaging necessarily is when you look at the way that they have drafted the term umbrella company in the draft legislation, um, it's very broad and it encompasses essentially recruitment agencies, temporary agencies, if they actually employ their temporary workers on contracts of employment, which some do.
Yeah.
Some did it back in the day under what we call the Swedish derogation model, which is now defunct. But, for various reasons, some agencies employ their temporary workers and some engage them on contracts for services as workers rather than employees. But if you're an agency that employs temporary workers on your books directly, then you will effectively be deemed to be an umbrella company for the purposes of this legislation.
Right.
And what that means is that your PAYE liability will be jointly shared with your client. So obviously, this is causing some concern amongst clients as well as agencies, and umbrella companies, because whilst I say there are some bad actors out there, there are also some that are compliant, they're members of trade bodies, they're really trying to do the best they can to improve the reputation of the sector and to act sort of fairly and responsibly. And I think their concern is that people will just think umbrella company bad, take them out of the supply chain altogether. But I mean, practically, what does that mean? That means the agency has to take the payroll in-house, and not just the payroll, but the employment of the workers. So it's not as straightforward as just saying, let's stop using umbrella companies. And actually, my view is that a compliant umbrella company has a place in the supply chain. But what it definitely means is that end clients and agencies are going to really have to do much more detailed due diligence on the umbrella companies that they are using, and potentially look at ways to give themselves some comfort that that PAYE is being paid, whether that's through certain software that shows kind of real-time reporting, whether it's through, strengthened contractual terms in your terms of business and indemnities, whether it's through, only working with umbrella companies that have taken out an insurance product to cover themselves in the respect of, in respect of any non-payment of PAYE. So it is going to be a fairly significant shake-up of the market in that respect. Now, that draft legislation is not actually in the Employment Rights Bill, it's in the Finance Bill that was only released in July. Again, that's in draft form and again is going to be subject to consultation this autumn, so it could change a bit more. So it's definitely one to keep an eye on.
Okay.
And that is due to come into effect from April next year, April 2026. So there's not a vast amount of time by the time the consultation is done for businesses to get their head around it. So I think it's really one to keep on top of and to start those conversations if you haven't already with either any umbrella companies that you use, or also your end clients, and think about what you're going to do. Are we going to bring payroll in house? Are we going to enhance our due diligence, etc.? The other aspect to the government's proposed changes in relation to umbrella companies is more on the legal side, and it's around the regulation of them. So umbrella companies at the moment are not really regulated by anyone. Recruitment agencies are, because they're subject to the conduct regulations and they can be investigated or inspected by the Employment Agency Standards Inspectorate. If you've ever had a visit from them, it's a bit nerve-wracking, but that is the government body that makes sure that recruitment agencies are behaving in accordance with the law and treating clients fairly and treating workers and candidates fairly. The remit of the Employment Agency Standards Inspectorate doesn't currently include umbrella companies, and the intention is that it will be expanded to include them, and that umbrella companies will be brought within scope of the conduct regulations. There is also talk about potentially having some kind of licensing regime for umbrella companies. So if you want to operate as one, you have to get a license, but that's kind of more up in the air at the moment.
But it would make more sense to do that, wouldn't it? Because then it's just from a, like you say, due diligence perspective. It's not something you can buy, it's something that you're awarded. And
yeah, absolutely. Yeah.
doing all these things.
Yeah.
So that's probably more pertinent than sort of the first angle of what we were talking about today. That actually, if you're listening now as an agency that does have temporary workers and you're using payroll companies and umbrella companies, this is what you should be doing right now. Like,
absolutely,
you take action. So that's really useful. And in terms of, if I'm someone sat listening now working for a company where I don't believe that we are taking this due diligence, time to get out and go and find a proper company. Without a shadow of a doubt. So how do founders put themselves at an advantage now, do you think? Like we don't know because like you say, the consultation is still going through. It could be that when we share this episode, it's possible it might have happened, but it's
Yeah.
like I say, it's probably possibly unlikely, certainly on this aspect. So what are the sort of steps that they can take to put themselves at a clear advantage so that they're not panicking?
I think they're twofold. I think the first is to look at their due diligence processes and really kind of expand them, make them much more detailed, really drill down into how are we going to satisfy ourselves that umbrella companies in our supply chain are compliant,
Yeah.
and are, you know, likely to be able to discharge their PAYE liabilities, because if they can't, that liability is potentially going to sit with you.
Yeah.
Um, and that's something that you can start doing now, kind of irrespective of what the legislation looks like. I don't think, due diligence is ever time wasted. Um, but the other thing I think is to start, firstly, talking to the umbrella companies in your supply chain. What is their view on this? What are they doing about this? Are they proposing to change their business model in any way? Are they proposing to introduce any sort of software or other mechanisms that will give you some comfort that they are discharging their PAYE liability? But also looking at what else is out there in the market. So firstly, you might take the view that, well, okay, going back to that point about umbrella companies potentially having to have a license. All right, we don't have a licensing regime at the moment, but there are various sort of trade bodies out there that have, in order for an umbrella company to be a member of that trade body, they have to have all their processes and documentation assessed. So the likes of the FCSA, SafeRec, Professional Passport, you might take the view, well, I want to speak to those trade bodies, and perhaps I will only have umbrella companies on my PSL that are a member of one of them. Now, I'd stress that that in itself is not just the green light to not have to do any further due diligence. Those umbrella companies are assessed by those trade bodies usually only once a year. And that it doesn't give you enough comfort that on a day-to-day basis things are necessarily being done as they should be. But it's a step in the right direction.
Known, isn't it?
Um,
Direction you would assume anyway, even if
yeah.
it's once a year assessment. But I was going to suggest trade bodies, so thank you for that.
Mm. Yeah. And I think just looking at, what other products are out there, there are various businesses now putting out products that help you sort of see in real time the tax and PAYE that's being transferred to HMRC. There are some question marks around whether even that is sufficient because, have they calculated it correctly in the first place? And, once it's transferred to HMRC, is it clear enough kind of what proportion of that tax liability that the umbrella company is paying relates to the workers that have gone through your agency? Because if there is a default by the umbrella company and they've not paid PAYE, and you could potentially be on the hook, but you're only one of many agencies that umbrella company is dealing with, of course, you only want HMRC to come after you in respect of your own workers that you supplied. You don't want to be holding the baby, as it were, for a different agency. And I think on that point as well, you need to be looking carefully, really at the sort of the financial stability and liquidity of the umbrella companies that you're using, because, if they go bust, even if it's not that they have, fraudulently avoided paying the correct PAYE to HMRC, if they just go bust
Yeah,
with PAYE liabilities outstanding, again, you could be on the hook. So you want to be ensuring that the umbrellas you're working with are, as much as you can, sort of financially secure.
yeah, absolutely. With that, I mean, these are all brilliant, brilliant steps that people can be taking right now, which is why I wanted you on now, as opposed to waiting till who knows when.
Yeah. Yeah.
But I really appreciate. Is there anything else you think people need to know? I know that you are really very prominent at co-hosting and hosting webinars on this. So is there any way that people can get in touch to see whether that's something that you can help them with?
Absolutely. You're very welcome to send me a message or follow me on LinkedIn. I post fairly regularly, as I say, about, significant developments, and will post about any sort of upcoming webinars or seminars that we've got on. You can also email me. My law firm is Brabners, hannah.morrison@brabners.com. If you want to sign up to our mailing list to receive details of upcoming sessions. Yeah.
Remember to mention the Recruiters Recruitment Podcast when you do that. Well, this is never going to be a goodbye. It's only ever going to be an adieu because you all will be coming back again in the future. I'm telling you that now because there'll be plenty more that we can be talking out. So for now, we shall see how the land lies when this podcast goes out, whether anything significant has changed. And if there has, then I'm hoping that when we share the post, you'll be able to just make a few amendments to what was a good intention in terms of recording date. But I think it's really important that we've still put this out there because there's still a lot that people can be doing, particularly around that umbrella company particular focus on that. Thank you, Hannah. I really appreciate you joining us again on the podcast.
Pleasure.